Hi, it's Mike DelSignore. In today's video, it's going to be first of a two-part series where I'm going to explain the process of an OUI case. In today's video, I'm going to talk about the process once you get arrested. So let's say this happens on the week, you're arrested on the weekend. What do you do on that weekend before court on Monday? What happens in court on Monday when you're going to appear for your arraignment, and what you should expect to happen next. So let's get started. So you're arrested immediately, you're in sort of panic mode. You call an attorney. Generally, when people call me, I'll start asking them questions to sort of get a sense of what the case is about. Now, I don't know completely how strong or weak your case is until I see the police report, but I can get a sense based on what you're telling me about where this case might be going. Because I've talked to a lot of people, so I know if you don't, just by your tone, your demeanor, how much you remember, how much you recall, and what court it is, the police department, I kind of will make some assessments on whether this case will be something hopefully we'll be able to take to trial, or you might resolve by plea. So first thing I want to know is, was there an accident? Why did they stop you? What was the driving reason that led to the stop? Because that can be a very key component of the case. I had a trial yesterday in Westboro Court where there was no bad or erratic driving, very critical part of an OUI case. Very difficult for the government to overcome a lack of erratic driving. So what I'm looking for is if you're all over the road, if there's an accident, those are signs of impairment. Now, let's say that's in your case there are some signs of impairment in terms of driving. There's a crash, or they're alleging, or often it's a civilian is saying they called complaining about you driving. Phrases we hear is you almost struck something, or things of that nature. So then, if there is some bad driving, we try to minimize it. So what I'm looking for then is, how'd you do on your field sobriety test? What other parts of the case can I point out to the judge or jury to create sort of a disconnection between somebody whose driving might show signs of impairment versus when you did the field test, when I say, geez, there was no signs of impairment there, you appeared to be responsive, following instructions, and there are other little sort of things that they do they look for, like how do you give the license, registration, how you get out of the car. All those could possibly be signs of impairment. The police are taught, they have a training manual that there's all these signs of impairment that aren't real tests. In other words, when the blue lights come on, do you pull over right away? Do you provide the license, registration? Do you get out of the car without leaning on it? Those are three sort of tests that they don't tell you are tests that are usually in the report. If you do those things well, you won't see them in the report. So initially, before the court date on Monday, usually it's on Monday if it's over the weekend, I want to know, was there alcohol in the car? Who were you with? Would these people be able to say that you weren't too impaired to drive? Do you have any medical issues that might explain problems with balance, like knee, leg, or back problems? Because then it lets me know that maybe I need to get some records, maybe I need to talk to some witnesses. I can talk to them even before the court date to get these people ready and to have them remember what potentially happened. If there's other things to do right away, potentially pictures and things of that nature, we can do that as well to make sure that none of the evidence sort of disappears. The court date then, and then typically what people will want to know, right away is, when are they going to get their license back? So if you refused a breath test, it's going to be a 6-month suspension, and if it's your first offense. So you'll be able to get your license back after the 6 months. Now, if you're found not guilty prior to the 6 months, there's a presumption of reinstatement. The only way to get your license back sooner would be, one, if you appeal the refusal, you might be able to get it back in 3 or 4 months. However, those are very difficult to win. I'd say it's somewhat unlikely you're going to have those overturned. I've had many overturned in my career, but I've had a lot of them denied. So it's a low percentage play, and I would explain that to you. Generally, I don't encourage people to appeal the refusal on a first OUI offense. If it's a second or third, then the suspensions are much longer, 3 years for a second offense, 5 years for a third offense, where it might be worth you appealing it, even though it's a slim chance. If you really need to just get back on the road at all costs, then the only way to do that is to resolve the case and then try to get a hardship license. So if you refuse the test, you're not getting back on the road quickly unless you accept a plea. I had somebody ask me some questions this week saying, is there a special hardship emergency? I have family that needs to go to the hospital, people I care for? And the answer is actually no. There's no special emergency hardship. The refusal suspension, the registry takes a hardline position on that there's no hardship unless you resolve the case and you're in what they call the 24D program. So if you took a breath test and it was over 0.08, you're in a little different situation. After 30 days, you get your full license back. Now, breath test evidence isn't necessarily reliable, so don't assume you can't win the case just because there's a breath test. I've had many trials just in the past 3 weeks with breath test evidence. Sometimes it doesn't come in. I've had it come in, and the clients have still been found not guilty. So understand that a breath test is just an estimate. It estimates your blood alcohol. So how does it estimate? Because the law says your blood alcohol should be over 0.08. So we get a breath test machine. So where do we get blood from a breath machine? It involves math, scientific formulas, assumptions that are not necessarily accurate for everybody. And these machines have a margin of error. So don't assume that this machine is infallible, it's perfect, and that the evidence will actually come in. DAs need to do various things to get breath test evidence into evidence, and sometimes they can't comply with the rules, regulations. So I often win cases with breath test evidence. It's not an insurmountable obstacle if you have a breath test in the case. More like a speed bump than a case where nothing can be done. So be wary if after you're arrested, you call around to different attorneys and you tell somebody about the breath test and they want to fold their tent quickly and say, oh yeah, you might as well take a continuance without a finding, breath test is over the limit. That's somebody that really doesn't do a lot of OUI work. Somebody that handles these cases every day knows that the breath test is often inaccurate, there are mistakes in the process, and knows how to contest this evidence at trial. But if you did take a breath test, the good news is, let's assume that the case is not otherwise winnable. In other words, let's say there's a crash, there's an admission, you said you drank a lot of alcohol, and the case wouldn't have been winnable whether there was a breath test or not. Well, you can get back on the road quicker by resolving the case. If you resolve the case within the 30 days, your 30-day suspension would end. You'll have a 45-day suspension from the date of the plea, and then you'll be able to move on. So there is a way to sort of move on quickly when you take a breath test and just get back on the road with your full license. So let me give you an example because this can be confusing. So if someone pleas out on the first day in the arraignment, and I don't generally recommend this, then the 30-day suspension would end and your 45 days would start. If you plea out in 2 weeks, then you would save 14 days. If you plea out on day 29, you only save a day because you've already served 29 days of the suspension. So you don't get credit for time, but the suspension essentially ends when you plea. There is an incentive to resolving the case quickly. Now, often you don't have all the evidence to know whether you want to plea or take the case to trial. So that's why it's not common to resolve the case quickly. It happens. Generally, it doesn't happen on the arraignment date, but if we get the case at arraignment and it looks, after discussing it, looks like you'll want to plea, then it makes sense to resolve the case. Sometimes we'll have the arraignment and I'll bring the person back in 3 or 4 days just to make sure that that's what you want to do, make sure we had a chance to look into everything. So once you're arrested, you're basically home. It's Saturday, Sunday. You want these questions answered. You want to know what's going to happen to your license. You want to talk to an attorney that's going to review the report and sort of give you an overview on what could happen. So the arraignment is when you formally enter a not guilty plea. You're formally advised of the charges. And if it's your first OUI, you'll likely be released on your promise to appear. Even if it's your second OUI, typically you'll be released on personal recognizance. So then your next court date is the pretrial date. At the pretrial, you're supposed to get any additional evidence the government has. And what could that be? It could be body camera evidence, additional reports, 911 calls, things of that nature. Generally, body camera doesn't really help people most of the time. It's better to get the booking video. In a case, the body camera, sometimes I request it, sometimes I don't. I generally like to see the report first. If I feel strongly about the case based on the report, I generally don't want a chance that the body camera might add additional evidence or make what I think is a weakness in the case into a strength. Basically, when I look at the report, I'm reading what's there, what's not there, And generally, an officer at trial will testify if something's not in the report, it didn't happen. So we have the officer locked in when we have a police report. So I like to use that report to sort of establish your defense, to get based on my experience and cross-examine these officers, I know how they're likely to testify. So this is an overview of what's going to happen immediately after you're arrested and the first court date. So the next step in the process would be, let's say you decide you want to fight the case, you want to go to trial, and at that point you'll have a trial in front of a judge or a jury. In the next video, I'll discuss what happens at the next stage of the process, motions, trials. But for this stage, I just want to really focus on the license, your initial decision to hire an attorney, and what's going to happen at the arraignment. So in some cases, I should mention this as well, if you crashed and went to the hospital, there might be what they call an immediate threat suspension. You should file an appeal with the Board of Appeals right away on that, because there's a very long wait. It's a 6-month wait to get to the Board of Appeals. So if you wait until the case is closed, you're going to wait another 6 months. It could take 3-4 months to get the case closed. So you want to get that out and get on their list as soon as possible. The other little tip that's come about since the registry does everything online or over the phone now, all hearings are over the phone. Let's say you resolve your case and you get a 45-day suspension. You want to request a hearing to reinstate your license basically within 30 days. So when you have 30 days left on your suspension, request a hearing. Otherwise, if you do it on day 45, you're going to wait another 20 to 30 days because the registry is backed up. So these are just kind of little tips that I've been able to pass on to my clients doing this every day and understanding some of the tedious nature of working with the RMV. So I'd be happy to help you explain defenses to your case, what's going to happen at the arraignment, walk you through my approach to a case and how I help people throughout the years avoid an OUI conviction. So my name is Michael DelSignore. Call, text anytime. You can reach me at 781-686-5924. I'm here to help. My passion is to help people charged with OUI cases throughout Massachusetts.